Good morning and welcome. It is Sunday, June 21st, 2026, and this is Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all so much for being here. Best Nancy, Little Miss Red Velvet, She Wolf, Susan D, Afton, and Kathy Mama Bear. Christina Chi-Town says, happy Sunday Fun Day and happy Father's Day to all the dads out there. That's right. Happy Father's Day, everybody. I hope you got a tie or a card or breakfast in bed. I myself am looking forward to my pair of socks that I get every single Father's Day. They're my favorite little gift. And if you had eagle eyes, you could have spotted one of those pairs at the panel that I spoke at CrimeCon. All right. Thank you, everybody, so much for being here. Hello to everybody who's in the chat. Thank you for waking up and joining us. Hello to everybody who's watching on Facebook or X. Please tell us hello if you are watching from one of those platforms. And if you're watching this on replay, we don't want to miss out on you. So please say hi. Let us know where you're from. We'd love to have those comments on the replay crew. Let me introduce myself to anybody who might be new here. If you are new, if this is your first time with us and with Sunday Fun Day, you're in for a treat. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for about 10 years or so before I left to go into private practice as a criminal defense attorney. And this is Courtroom Confidential, where we do our best. We have made it our mission statement to present to you both sides of the courtroom, both sides of the issues, both sides of the stories. And we hope that we do that. And this is Sunday Fun Day. It is a show where we take your messages. You've left us voicemails throughout the week, and we're going to answer them live today. And it's becoming our favorite show. It is our favorite show, I think. So thank you, everybody, for coming back, and welcome everybody who's new. Stay to the end. We do have some announcements. Don't go anywhere just because we get to our last question. There's some stuff I want to share with you. But right now, take that big cleansing Sunday morning or Sunday afternoon, Sunday evening, wherever you're watching from, breath. You made it to Sunday. It's the end of the week or beginning of a new one, depending on how you look at it. Hit that like button if you haven't already. Subscribe if you haven't already. And share this with anybody that you feel might enjoy it. And let's jump into our questions, shall we? All right. I think I'm ready to go. Who's kicking us off this morning?
Hey, Josh, it's Taylor from Bluffton, South Carolina. And I was watching the documentary about Michael Barisone, the untold episode on Netflix about the shooting at Hawthorne Hill. And I was confused because he actually won, I guess if you can say it's winning, on the defense of not guilty by reason of insanity. And they were stating and showing that he was out within like something absurd, like a year. I thought that if you were found basically not guilty by reason of insanity, that you still had to serve a similar sentence to like whatever you were being charged with. I didn't realize that you could get out and live your life within 1 year. So I was just wondering, what does that look like in regards to the other cases that we're following with the not guilty by reason of insanity? So if you could, I guess, just shed some light on what that looks like, that would be awesome. Thanks. Have a great day.
Taylor from Bluffton, South Carolina. Let's put you on the map. Thank you so much, Taylor, for kicking us off this morning, representing the Carolinas. Appreciate you joining in on the conversation. And it's a good question. We've talked about this before. We've talked about what actually happens when somebody is found not guilty by reason of insanity. And I feel like I've said time and time again, don't worry. It's not like they're getting out right away. They usually spend more time in this sort of civil commitment for their mental health than they would actually spend if they were convicted of the crime, on and on and on and on. And then Taylor points out the Michael Barisone case. You guys may have remembered this one. It wasn't all that long ago. It was followed fairly heavy in the true crime sphere. Now, everything I just said about NGI cases is true. They don't get out right away. They do statistically spend more time in the custody of a mental health institution than they would have spent had they been convicted. They do statistically usually spend the rest of their life there because they're very unwell people. But there are exceptions, and this is a very wild one. And I think this is more of an indication of perhaps a verdict. I put it to you this way: I've got more problems with the verdict than I do with the entire concept of not guilty by reason of insanity. Let's go through this really quickly. He is, Mr. Barisone, an equestrian dressage trainer. This is where horses, I don't know anything about this. I'm just reading about this. This is where they ride horses and the horses perform different it's not like jumping things. It's like the way that the horse, I don't know, trots or gallops. Somebody help me out here. Afton, I'm throwing this one at you. It's kind of the way that they're able to make these horses perform almost like dancing, but it's not what you see at the Olympics where they're jumping things and racing. This is something very different, but it is an Olympic sport. Yeah, music's a part of it. It's like a performance. It's like a, when you see kind of the more artistic side of the Olympics, this is this with horses. Anyhow, he's apparently a big deal in this world. He had been an Olympic competitor, I think, himself, but then he became more known as a trainer in this world. Well, he meets a woman by the name of Lauren Kanarek, who is an Olympian in equestrian dressage, and he agrees to train her. And part of that is he even houses her. She moves into his property. He's got this big property that's got a horse stable and areas for the horses to dressage or whatever you want to call it. Her and her husband move in, and things turn sour. They get into it. There's all sorts of disagreements. Things turn very heated, and he wants to evict them, and it becomes really ugly. And depending on who you believe, and I did not watch this documentary, it's on our watch list. One side is blaming the other side for making it far more heated and difficult and ugly than it needed to be. Well, in any case, Barisone decides that the eviction process is not moving quickly enough and that they're not getting off of his property. So in August of 2019, he calmly walks up to her with a gun in his hand and shoots her point blank in her chest 2 times. Then turns the gun on her husband and shoots at him. Now, I think he misses the husband. I hope I'm right on this. I don't think he actually injures the husband. But she goes into emergency care, critical care. I think she's in an induced coma to survive this. Barely survives. So we're not talking about a murder case. We're talking about an attempted murder case, but 2 counts because he shot at Lauren and he shot at her husband. They go to trial, and at trial, he brings a not guilty by reason of insanity defense. Yes, you can bring these for situations that don't involve murder. So he brings it here. He makes an argument. He calls experts. He calls doctors, and they all, on his behalf at least, testified that he was suffering from incredible anxiety and stress induced by this living situation, and that he was having delusions. Now, he was looking at 60 years in prison had he been convicted. But he's not convicted because they find him not guilty by reason of insanity. The prosecution, by the way, put on a good case. They made all the arguments. They put on their own experts. It just didn't win the day with the jury. And he's acquitted now, right? You're not guilty by reason of insanity. Before trial, he had spent 2.5 years in prison, just to be fair. After trial, he goes into a civil commitment, which is what usually happens for people who are insane, and they then go about mental health evaluations. Well, He goes in April of 2022, and by 2023, the evaluations come back that, yeah, there's nothing wrong with this man. He's safe to re-enter society. So he's out. He's out after a year of confinement post acquittal. So altogether, he probably did 3.5 years, if you want to be fair. But after the acquittal, he only does a year in this mental health commitment. That is wild. Now, is that a breakdown in the system? And is that something that should give us all great pause and concern about this? Well, I mean, it's hard to say no, but I will say that this is a wild exception to how this usually works. And again, I don't think that's a breakdown in the facility. In other words, I don't think that there were doctors that were really I don't know what's the word I'm looking for. Dishonest in their evaluations from him, and we're just like, no, we're going to get a crazy guy out of our institution here, out of our hospital. I think that legitimately they probably found there's nothing wrong with this man. He's safe to return to society. I think it more shows you, you can kind of get experts to say whatever you want, and these experts in this defense put on a hell of a defense. And we're able to, again, I'm trying to respect the jury's verdict, but I feel like they were bamboozled here. I feel like there was probably nothing wrong with the guy. Yeah, he was suffering from stress, I'm sure. Yeah, he was probably, at his wit's end, but doesn't mean he's insane for the purposes of insanity when we're talking about a criminal defense. Usually that means, or not usually, always that should mean, is that you were so untethered from reality that you didn't even know what you're doing was right or wrong. Can that be temporary? Sure. But that's a heck of a temporary that it only lasted about a year before they decided he was well enough to be released. So he's out. He is out. He is trying to still participate in the world of competitive equestrian dressage. But I will tell you, fortunately, that he has been banned by the Olympic Committee because, they don't look too kindly on shooting other competitors. Anyhow, great question. Yes, there are always exceptions, and these exceptions are what make people very nervous about the whole concept of not guilty by reason of insanity. Thank you so much, Taylor from Bluffton, South Carolina, for kicking us off this morning. Annalie Finch says, "Am juiced for Sunday Fun Day. Are you?" Sounds like a challenge, everyone. Are you juiced? Ann Potter is. She says, "A great big happy Father's Day to Josh." Thank you so much, Ann Potter. That's very kind of you. And Seashell, thank you for the very generous support. Says, "I caught you live. What a true gift." Well, it's very, we feel the same way. It's a gift to have you here. And thank you so much, Seashell. All right. Let's keep it rolling. Where are we off to next? A lot of great questions this morning. All right, here we go.
Hi, Josh. It's Mary from Carthage, North Carolina. I used to live in California, and I used to work for a criminal defense attorney out of San Francisco, who, after many years, decided that he was going to go to civil practice because of having to deal with criminals. And it was basically legality versus morality. And I don't think I've ever heard you talk about that much, about how difficult it is to compensate for the two. Looking at several cases, Alex Murdaugh comes to mind of, does it make me feel good that he's getting a new trial? No. But legally, does he deserve it? Yes. And that kind of, Nick Reiner, does he deserve the money? I don't know. I don't know why he didn't get it when he was 30, but it has nothing to do with after the fact. So it's kind of that kind of question. I don't know if that makes sense or not, but I'm talking too long, so I'm going to stop. And happy Sunday Fun Day. Thanks.
Mary, thank you so much, from Carthage, North Carolina. Wow, look at that. We got the Carolinas covered this morning. South Carolina, now North Carolina, putting you on the map. I get this question every so often. How do you deal with kind of the moral ambiguities of being a criminal defense attorney? And I understand the question completely. I probably would be asking the question myself if I were not, so intimately involved in the career and having been on both sides of these criminal issues for so long. And it's still a good question. I think, even if you've been in this career for a while, to consider, to worry and think about these things. It's something that attorneys, even, criminal defense attorneys and prosecutors talk about. And I guess the short answer is, yeah, it is difficult, and it's probably not a job for everybody. If you're a person who very much sees the world in black and white, right and wrong, it's probably not a career path for you. It is a career where you do run into situations that are going to really make you take a gut check about where you stand on things. But I think for the most part, you talk to most criminal defense attorneys, and they are people with incredibly strong ethical and moral feelings about things. But one of those feelings that they feel very strongly about is that everybody deserves a defense, and that there are sometimes ugly jobs out there, and that even people who have been accused of the most heinous things on earth doesn't mean that the Constitution somehow has a asterisk for those situations. And that much of what a defense attorney is doing is not the goal of, let's get this guy off, let's find some loophole, let's trick people, let's pull the wool over people's eyes, let's lie, let's do whatever is necessary to get this horrible murderer back on the streets. It's much more about, let's make sure that the checks and balances in the system are being handled correctly. Let's make sure that the government, in doing their job, is not trampling all over the Constitution and this person's rights to get where they're trying to go. That's a lot of what criminal defense work is. It's about making sure that what the government did was legal and right. Say it louder for the people in the back. It's about saying, you got a warrant? Fine. You found a bunch of evidence? Great. You found a head in the a severed head in the trunk? Okay. Did you do it the right way to get it? Did you have probable cause? Did you have a warrant? Is the warrant correct? Let's double check your work here before we're going to just go ahead and throw away the key on somebody. I think it's much more about that. Now, are there cases that, I just simply cannot get past that? Sure. And that's why I feel like I'm in a very unique place that I enjoy being, where I can say no. There are cases where I say no. This is just not the case for me. Not passing any kind of judgment on that person, but I'm saying, hey, listen, you might be better suited with a different attorney. There's types of crimes I just won't handle. Some of that has to do with, I'm uncomfortable with the subject matter, and other of it has to do with, I just don't, paper cases. It doesn't have to be something nightmarish too. I don't necessarily want to get into the years long nitty gritty of whether or not you filed your taxes properly. Not really my bailiwick. So I hope I'm answering your question, Mary. I know a lot of people ask this, but I will say this. We all want justice, but we all want to know that it has been done the right way. And if you don't have these people on the other side of the verses representing really awful people and doing it with the same integrity and advocacy that they would with any other person, then you're going to have breakdowns in the system, and it's going to create problems. And none of us want that. So thank you so much, Mary. That was such we appreciate the question. We appreciate you calling in from Carthage and putting Carthage on the map. Arizona Gal says, happy Father's Day, Josh, and to all the dads, grandfathers, stepdads, adoptive dads, and dads in heaven. Today we celebrate you. Couldn't have said it better. Thank you so much, Arizona gal. Afton, thank you so much. Says happy Father's Day to those celebrating. We appreciate you. Peace to those who are hurting today. Oh, that's a very good way of putting it as well. Thank you. And from the Gonsalves family page, hi, Josh. Well, hello, right back at you. That's incredibly nice of you to stop by and say hi. I was actually had the pleasure of meeting the Gonsalveses in Las Vegas. So if that is you stopping by to say hi, hello, and I appreciate it. And it was a real moment for me to sit there and chat with you all. So I appreciate having met you, and I hope to speak again soon. Thank you so much for being here this morning. All right. Let's keep it rolling here, shall we?
Hi, Joshua. It's Jim in the Marshall Islands. I have kind of a theoretical question in terms of client-lawyer confidentiality and lawyers' ethical behavior. I think I know that lawyers can't knowingly help their clients lie. But can they sort of hint at their clients lying? I'm thinking in terms of Charlie Adelson's ridiculous lie about the double blackmail, the double extortion plot. I mean, is it theoretically possible that he sits down with his lawyer, they see all the texts, all the voice recordings, they have to come up with something? I mean, can the lawyer say something like, is it possible that maybe somebody else was blackmailing you before? It's not really telling him to lie. It's sort of coming up with, could this have happened? Could that have happened? I can't believe that things like that don't happen, I would say, fairly routinely, where they suggest, oh, maybe you're forgetting that this could have happened. Could that have happened? And in terms of lawyer-client confidentiality, if that is unethical, how would it ever be revealed? Would the client himself have to file some kind of suit?
Jim from the Marshall Islands. You heard that right, everybody. We have representatives in the South Pacific. I've assigned Jim to the entire Pacific. So that's all on you, Jim. You are now the leader of our fan club out in the entire South. Now we're going to give you the whole Pacific. There's really you and a couple other people there I can see. Great question, though. Really great follow-up, too, to the last question about moral ambiguities and, let's get down to the nitty-gritty. How close to the line are you going to get when it comes to lying or allowing your client to lie? So a lot to unwind here from Jim. First of all, many times clients will come into an attorney's office and they already have a story, right? It's, I didn't do it. I did it, but this is why. Everybody's got it wrong. And sometimes they're sticking to that story. And sometimes attorneys, because, they're not stupid people, might realize that there's significant gaps in proof behind those stories. And I think the better attorneys will confront their client with that. Okay, dude, this is what you're saying happened. However, it seems as though we're going to run into the obstacles of a significant amount of evidence to the contrary if we try to make this argument at trial. But listen, this is their trial. This is their life on the line. And if that's the defense that they want, then you either give them the defense they want or tell them to move on and find a lawyer who will do it. Other times, when we're not talking about, I should be clear, talking about the defendant actually testifying. Let's just talk about arguments made in court. Arguments are different, though, than facts, right? In fact, the judge even tells jurors that arguments are not evidence. Arguments are simply that, arguments. And I think that's where attorneys can be a lot more clever and a lot closer to those lines without crossing them. Because it's one thing to say a flat out falsehood. And it's another thing to say the evidence suggests this as a possibility as well. The evidence suggests that what the prosecution is saying didn't happen. And there's a reasonable interpretation of the evidence that suggests X, Y, and Z. And those arguments are made all the time. And you may look at them and go, well, that guy's lying. Well, he's not lying. He's arguing. Now, where things do get very close to that line is about what if your client is going to take the stand and you know what they're going to say is false. Now, what does that mean about knowing? Well, if they've been telling you since day one they didn't do it, then that's their testimony. And if they want to get up there and say they didn't do it in spite of all of the other evidence, I wonder how much of that is actually lying or just this guy telling his story. And I know you're saying to yourself, well, isn't that a lie anyways? Well, if your client is going to get up there and say, I've never owned a gun in my entire, not only did I not shoot the victim, I've never owned a gun in my entire life. And your client handed you the gun and said, could you please put this in your safe? Well, now you know they're telling a flat out lie, right? It's one thing to say, I never shot the guy. Well, nobody was there. There's no eyewitnesses. We don't know. He could say, I never shot the guy. Fine. But if you're saying I've never seen a gun in my entire life and you yourself personally know that's a falsehood, that's where things start to get really hairy for a criminal defense attorney. And that is many times where you'll see defense attorneys saying, I'm not going to participate in this. And I'm going to let the court know this. And I might have him testify in the narrative form, which is incredibly rare, but we've seen it happen before. But one line I do think should not be crossed is that line of perpetrating an actual falsehood on the court and participating in that by asking your client to testify to those things and asking them questions that further that falsehood, like in the situation that I just outlined for you. Robert Tellez is a good example. He testified in the narrative because his attorneys probably knew he was going to say things that they themselves knew to be false. Again, there's walk these very precarious lines with me here. There's one thing to say, I didn't shoot the guy. Well, I don't know. I wasn't standing there. In Tellez's case, there's one thing to say, I didn't stab the guy. I don't know. I've never been there. And it's another thing if Tellez told his attorneys, yeah, I stabbed the guy, but I'm going to testify that I didn't. Now they know there's a falsehood, right? And that's where you'll see these things in narrative form come out. Now, on top of all of that, Jim asks a very great question. Well, in the situation that I gave about the gun, let's say, the only people on earth who may know that are the client and the attorney. So how is that ever going to come out? And you're right, Jim. It's kind of on that attorney. And how do they want to sleep at night? Do they want to sleep very comfortably knowing that they have never, kind of crossed their own boundaries and never put their bar card at risk? Or are they thinking to themselves, nobody's ever going to find this out, and I like winning? I remember I talked to a defense attorney one time when I was a prosecutor, just jokingly. This wasn't ill-spirited at all. And I said to him, how do you sleep at night? And he said, on 1,000-count sheets. And I thought that was a perfect answer. A lot of people, you're right, Jim. There are a lot of people who just don't have as much of an issue with it. And they like winning a lot. So again, great questions, Jim and Mary before you. It's like I said, it's not a job for everybody. And I hope I'm not explaining this all to you to say boy, Josh really chose a morally precarious job. I will say it's a job that has you checking your own compass far more than most jobs do. And if you're comfortable with that, then you could do it well. But if you're not comfortable with that, and some people aren't, they go on to different careers, different parts of the law. Maybe they become YouTubers. I don't know. All right. Thank you so much, Ali Foley, for the gifted memberships. That's very kind of you. Appreciate that. Therapist, thank you so much for gifting the membership. Kind of you as well. And Chihuahua Mama says the smartest crew, everyone included on YouTube. I couldn't agree more. All right. Where are we off to now? Great questions this morning.
Hey Joshua, this is Ashley from Columbia, Missouri. Longtime listener, first time caller. And I'm calling about the new Netflix documentary, Maternal Instinct. In the documentary, it only shows, or it only talks about, I guess, her being charged with the murder of Reagan. But as we see the documentary, it seems like there's so many other charges that could have been pressed. Maybe they're financial or I'm not sure because of all the schemes and stuff. I know that there's a lot of things that maybe were immoral, but maybe not illegal. But there definitely was some things in there that felt like there could have been additional charges pressed. So as a prosecutor, I guess my question is, how do you make decisions on what to charge people with or what not to charge people with? Especially if there's multiple options and you can do things from different facets like financial and the murder and all of those different areas. How do you decide, like, oh, we're not going to do the charges on this, we're just going to push for this one area? So that's my question for today. Thanks so much. Bye.
Ashley from Columbia, Missouri is a first-time caller, everybody. Round of applause for Ashley. Thank you so much for participating in the conversation. Love the first-time callers. I know it's not easy to do. I know I get a lot of people who say, oh, I want to call in, but I don't know what to ask. I don't like the sound of my voice. Call in. I don't know what to answer, Ashley. Yet here I am. So thank you so much for participating in the conversation and putting Columbia, Missouri on the map. And it's a great question. Let me say this. This documentary from Netflix called Maternal Instinct is wild. It is crazy. And I want you guys to watch it. And I don't want to spoil it for you if you aren't familiar with the case. It was a fairly big case a few years back, but some people might not be familiar with it. And it is one of those documentaries where there is a shocking moment in it. So I guess I'm saying all of that to say a bit of a spoiler alert, because I got to get into it. Sorry, guys. So if you want to watch this and you haven't watched it yet, I don't know, mute things for a second. Don't go anywhere. Don't take off. Just mute things for a second. But here's the story. Everybody fully warned? Okay. Here's the story. This is Taylor Parker. She is a young woman living in where was this? Oklahoma? I feel like it was Oklahoma. And she's a very troubled young woman. She's very kind of delusional, but very charming. Everybody who talked about her in the documentary talks about how was kind of the life of the party and fun to be around. Anyhow, she meets a man was his name Cody? Why didn't I write down everybody's names here? There he is. What's his name? Wesley? That was it? Wesley? Very nice guy too. Oh, it was Texas. Everybody's telling me it was Texas. Very nice guy. Sounds like a sweetheart of a man. They fall in love. She's Wade. Yeah, that's it. Wade. She's got Wade Griffin. It starts off with all these tales about that she's like due to inherit all this money, that she's got some falling out with her mother. So she's got an answer for everything. And then things, it sounds like, start to unravel a little bit. Cars that she's purchased for people get repossessed, properties that they planned on buying, she never follows through with the money. And lo and behold, Taylor gets pregnant. And this is, again, spoiler alert here. So if you want to watch it, watch it. But I'm about to tell you some of the shocking moments here. I got to do this, right? Like, I can't tell this without telling the shocking parts of this. Then we find out Taylor can't get pregnant because she had had a hysterectomy. And there are only a few people who know this. And those people are not exactly sharing that information with poor Wade and his family. They're going along thinking she's pregnant. She goes out and takes, expecting mother photos. And they're throwing this is part of the photos that they did, because she was, at this point, they thought 8 months pregnant. She goes out and she does, has herself a baby shower, the whole thing. Yet the baby's not coming. And she's producing, sonograms and doctor's reports. And now she's late, past her due date, a week, 2 weeks, 3 weeks. People are starting to ask more and more questions. I'm leaving out a lot of the good stuff too. So believe me, you'll still have plenty of surprise. But the real kicker is she had a friend by the name of Reagan Simmons, who is also pregnant. And due around the same time that Taylor was, quote unquote, due to give birth. I mean, there's no other way to set this up. She goes to Reagan's home, kills Reagan, cuts her baby out of her 8-month, 36-week pregnant baby. It was a daughter they were expecting by the name of Braxlyn Hancock, and then heads off to the hospital with the newly torn out of her mother's womb baby in her lap. And they get her to the hospital, and the baby dies. And the doctors start to examine her, and they say, this woman has never been pregnant. And you can see it in the documentary where the nurses start to have this overwhelming idea of like, well, wait a minute. She came in here bleeding. We have a baby. We tried to save the baby's life. There's an umbilical cord and a placenta. What's going on here? Investigators get involved. They try to talk to her. Doctor comes in, does a final exam, says this woman was never pregnant and never gave birth. And she ends up getting arrested, and she's charged with 2 counts of capital murder for the murder of Reagan and little baby Braxlyn, and along with kidnapping. And she is sentenced to the death penalty. And she is, I think, the youngest female currently on death row in Texas right now. It is a nightmarish, horrific case beyond belief. And the only other thing I'll say about this is that Taylor, as kind of crazy as she was, never exhibited signs like this. Like, she was robbing and stealing and lying and all of that, but never like signs of violence. And to have committed this actual act of what she did, it is just so beyond fathomable that, that kind of violence. Watch it anyways. Even if I just spoiled it for you, watch it anyways. It's well worth it. Now, all of that is a setup to answer your question, though, Ashley, about what do prosecutors decide to charge and how do they decide to charge it. This case is actually a pretty good example. They probably could have charged other things. Mutilation of a corpse, kidnapping, breaking and entering, residential burglary, all of these other things. Lying to hospital staff. I mean, they're fraudulent, blah, 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 blah. And this occurs many times in crimes, that it's not just, somebody committed a murder and that's about it. They usually are committing crimes along the way, right? You know, illegal possession of a firearm, possession of a firearm in a facility where they shouldn't have one, blah, 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 blah. The discerning and smart prosecutors go with just the big stuff. And every once in a while, you'll see cases where they add all the other bells and whistles, and it really is distracting, and it sounds like overcharging. And I think more than anything, it confuses the jury. This is a murder case, and that's it. Were there other crimes committed along the way that are window dressing for the murder? Sure. But don't distract the jury, because you got to prove every one of those. Otherwise, you're going in and dismissing all of them, or she's found not guilty on a bunch of stuff that you didn't take the time to prove, or you have to sit there and prove all of those other things. This is a murder case. Stick to it. And we see this time and again. Keep your eye on the ball. Stick to what this thing is important about. More often, cases suffer from overcharging than they suffer from undercharging. More often, prosecutors do themselves a favor by trimming down their case than by adding to it. So I hope that answers your question, Ashley. But more than anything, if you guys are in the right mental space, I will say this: it had both Tiffany and I shook. I am rarely shook, and you can ask Tiffany. There were a couple of times where I had to. It's like, holy moly, what do you got me watching here? It's her fault. She's the one that wanted to watch it, but it was incredibly entertaining. You do not want to stop watching it once you started. So check it out. All right. Thank you, Ashley from Columbia, Missouri. Best Nancy, thank you so much for gifting the membership. Very kind of you. Joy, thank you so much for supporting the mods with coffees. That's very, very nice of you. And Long Island Hillbilly says, Josh, you're always winning with us. I like that. On a Father's Day. That makes me feel good. Ali Foley says, the hospital in the Netflix documentary had to issue a statement asking people to stop visiting it randomly. Oh, my God. Crazy. Yeah. It is. It's a wild one, guys. Really disturbing. I don't want to dwell on this, but just if you feel like you can, for a moment, imagine the actual logistics of doing what she had to do. This is not a simple procedure. And I'll just leave it at that. All right, let's keep it rolling here. Where are we off to next? Here we go.
Hi, Josh, mods, CC crew, everyone. This is Jessica from Raleigh, North Carolina, also known as Red Bunny 1024. And I have a question that I was inspired by a caller from last week. I have a hypothetical land of make-believe question for you, Josh. If money is not a factor, if you were charged or prosecuted with a crime, a criminal case, who would be your OJ dream team? Of course, this is nothing heinous like, murder or anything like that. For me, I think it would have to be you, of course. The attorneys for the Uvalde shooting, Nico LaHood and Jason Goss. Matt Murphy, of course. I think everyone thinks he's so handsome, and he is. Mark Garagos, despite his defense of Scott Peterson, who I actually share a birthday with, different year. Camille Vasquez and Benjamin Chu from the Johnny Depp trial, and several YouTube attorneys that I just won't have the time to name. But anyway, I can't think of many women attorneys outside of Camille Vasquez. So, because I don't watch a lot of trials. But anyway, I thought this was an interesting question, and maybe you've been asked it before, but if you have, it's been a while and I haven't heard the answer. So interested to hear your response. Thanks.
Great question, Jessica. From North Carolina. We got the Carolinas are really representing today. I love that. Great question, Jessica, from Raleigh, North Carolina. I loved this one because the second I heard it, I thought, we're going to get a lot of people in the comments making suggestions on this. And I'll tell you, we had some internal debate ourselves amongst the CC behind the scenes crew about who should make the list here. And there's plenty of people. You mentioned a lot of them that are fantastic. AJ, Josh Ritter, Matt Murphy. I'm very honored to be amongst that list of people. Robert Elleshia, there's another one. I mean, one of the ones that comes to mind immediately, you mentioned the OJ case. Whenever I think about the OJ case, I think the unsung hero of that whole thing is Barry Scheck. He was there he is. He was the DNA expert. If you want to know why OJ was acquitted, that's the guy. Johnny Cochran gets all the credit. And Johnny Cochran, gets the if the glove doesn't fit, you must acquit, and everybody remembers that. This is the guy that won the case. I mean, he just put on a master class in how to cross-examine forensic experts. He set the blueprint for attorneys for generations to come on how to handle forensic evidence and how to cross-examine experts and how to present, create questions in reasonable doubt. And people still, to this day, when you have a high forensic case, they're doing their best Barry Scheck impersonation. So a lot of people come to mind. The one but I imagine you're kind of thinking about more present day, currently, who would I call right now? I've gone mad. I've murdered someone because they said an unkind word to my wife, and now I'm on trial. Tiffany likes that. Who do I call? Barry's long since retired, I think. Who do I call? The guy that we landed on was Brian Steele. You remember him? This is the attorney who represented Young Thug in the YSL racketeering case out of Georgia. This guy was just a rock star, I thought. He just fearless. First of all, very good. He's got all the things that I admire in defense attorneys because he wasn't all that flashy. It wasn't just, all style. He was a fearless advocate, very good. I mean, on his feet and the way he presented himself and thinking on his feet, but also, tremendous substance to back it up. And then the second you guys remember that moment where the judge was finding him in contempt and was going to literally lock him up because he wouldn't give up a source on a situation that he shouldn't have had to give up the source. And he starts taking off his jacket, and his only request is, whatever you do, can you house me next to my client so we can still prepare for court? And I was like, that guy. If I ever get in trouble, Tiffany, call Brian, because that's the guy you want standing next to you. And I think he does exemplify what really makes a good defense attorney. I think he's very ethically sound, fearless, just a badass. Yeah. So I mean, listen, you guys are suggesting a bunch of great people. Any one of them would be fantastic. But if I had to, go with one, if Barry Scheck is not willing to come out of retirement, or if it's not a DNA case, like I didn't leave a bunch of forensic evidence around in the commission of my crime, I'm probably calling Brian Steele. If I can afford him. But you said no money. Money wasn't an issue. So there you go. All right. Thank you so much, Jessica from Raleigh, North Carolina. I appreciate that. Where are we off to now, guys? Are we having fun? Are you guys juiced? Are you enjoying yourselves on this Sunday morning on Father's Day? I hope so. Here we go. Not my fault, Kaylin.
Hi, Josh. Courtroom, confidential, crew, family, mods, team, the whole gang. This is Erica calling from Tulsa, Oklahoma. I've really been thinking a lot about the outdated Son of Sam laws that do not include all of these streaming services and live chatting or live, all of the new ways that people can make money. And I know that Dominic Russo's family is trying to get a Dom and Davian law passed. And I heard today that the Huremans profited off of that Peacock documentary, which I refuse to, give my support to, because while they didn't do anything wrong, I don't think they should be able to get money off of it either. So how can we go about getting a law that's nationwide, that's updated to today's life or today's ways of being able to make extra money and also make it nationwide? I'm pretty sure I was taught that in a civics class or some kind of class like that in college, but I'm rather old and I don't remember those things. So can you help me understand better? I thank you so much. Bye.
You just made me think of what was it? Oh God, I'm Just a Bill sitting on Capitol Hill. What was that show? What was that children's show? Oh, I'm getting sideways eyes from Kaylin and Tiffany, of course. You guys know. What was the name of that? School. Oh God, this is going to drive me nuts. But it was, talking about the question of how do you get, not Sesame Street, no. Schoolhouse Rock. That was it. Schoolhouse Rock. Go watch Schoolhouse Rock. That'll answer your question. How do we get a law passed? Yeah, I mean, short answer is call your congressman. Say, hey, do something. I think actually you'd probably get somebody to write something up. I mean, who's going to oppose this? It's probably very politically advantageous for a congressman to put this legislation together because you're not going to get a lot of fallout from your constituents, no matter which political leanings you have. I think everybody would agree that we don't want murderers profiting from their crimes. But I know that you, Erica, are saying we should probably extend it beyond the defendant themselves. Mackenzie Shrilla, people bring this up all the time. Is her family making any money off of this documentary? Were they paid out by Netflix? I don't know. I think the answer is probably yes. I know Netflix throws around money like they've got a tree in their backyard and pay people big money. I know that that Huerman's wife received a huge payout from Peacock to participate in this documentary. And people are, and I think rightfully so, upset about that because you think no one should profit from this. I guess the question too, though, you have to think about is where do you draw that line? Let's take the Huermans. And again, hear me out here before you come at me with the pitchforks. But his wife, and why am I blinking? I'm blinking on everybody's name today, but I get a pass because it's Father's Day. His wife, Asha, is that how we're pronouncing it? Asa Ellerup. All evidence points to the fact that she did not know what he was up to. Okay. You may say, poo on that. I look at it and I go, I don't think she did. I don't think the kids did. I think he went to great lengths to make sure they didn't know. I mean, they can nearly track down every murder he committed to a time that she was out of town. Okay. Let's, for the purposes of my arguments here, say she didn't know. Now you've got a person whose life has been torn apart horrifically. No, it's nowhere near the damage caused by this man, but it's still damage. These poor kids, their names are plastered all over the place. They will never not be known as Rex Huerman's son or daughter. She will never not be known I don't care, divorce, changing her name, moving, somebody's going to find out who she is. This is something they will carry around for the rest of their lives. That's the wife. That's the daughter of that guy that killed all those women and left them on Gilgo Beach forever. Already having trouble finding employment is my understanding for the daughter. Already financially devastated this family. Now, does that mean I think they should be able to exploit the situation, go out and make a bunch of money and go on a book tour and all of this other stuff? I agree with you. I think I'd probably have a problem with that too. But these people are victims as well. Not the same degree. We're not trying to compare degrees here, but they are victims. And a part of me goes, well, listen, they have a story. They have a lived experience that I think they should be able to share. And I also, a part of me thinks they should be able to sell, right? I mean, you know, what is it like being the daughter of a serial killer? Is that a story that people want to hear? Is that a story that you want to share? Is that a story that you should be able to sell? I don't know if I've got the answers. I'm just saying it starts to become a little less clear, a little less black and white than when we're talking about the defendant. If you want to talk about the defendant, I all day long, I think that we should find out every opportunity to make sure that they're not profiting in any kind of way. And if you want to make that a federal nationwide law, go for it. It just, to me, gets a little more, you know, and then at what degree do we stop that? Is it like immediate family? What if it's the best friend of this person, of Huerman? Knew the guy for forever, worked for him forever. I want to write a book. I was his cousin. We talked all the time. I had no idea he was murdering women. I want to write a book. I want to tell my story to Hulu and have them pay me for it. Starts to get a little less clear is all my point is. But great question, Erica from Tulsa. Something we haven't really talked about all that much. I think it's very interesting. Go to your congressman is the answer, though. All right, let's keep it rolling here.
Hi, this is Don in Hoboken, New Jersey. A lawyer once told me that attempted murder is the hardest charge to prove. I think he said it because if you really wanted someone dead, they would be dead. Do you agree? Do you think attempted murder is the hardest charge to prove? And am I thinking about this correctly? Thank you.
Don, one of my dudes from Hoboken, New Jersey. Great question, Don. I have heard this before. The best way to get an answer to this is to go to somebody who has a lot of experience in prosecuting both murders and attempted murders. And luckily, I was able to do that because I was able to phone a friend.
Hi, criminal defense attorney Donna Rotuno here to answer Don from Hoboken's question. Don asked a great question about why attempted murder cases are notoriously difficult to prove and if that is in fact the case. And it is, Don, and whatever lawyer told you that is absolutely correct. The reason they're difficult to prove is because they require the prosecutors to prove beyond a reasonable doubt that the specific intent of the person attempting the murder was to kill, not injure, not maim, not harm, but to actually kill. Now, of course, the prosecutor's response to these things are if you fire a gun in the direction of someone, if you stab someone with a knife, those are deadly weapons, and the intention is to kill if you're using a deadly weapon. They do prove these cases all the time in courthouses across the country, but because they need that specific intent to kill, it is difficult to prove those cases at times. Good question.
There you go, Don. From one Don to another Don. Donna Rotuno, a nationwide, highly respected and highly sought after criminal defense attorney who was a prosecutor in Chicago. She's also a dear friend, and she's also the host of a fantastic show on Fox Nation that she co-hosts alongside a couple of really handsome guys. So you should check it out, called The Weekly Rap Sheet. But that's a great answer to there they are. there's the handsome guys on the weekly rap sheet. Check that out. She also hosts her own podcast, which I want you guys to check out, called Crime and Justice with Donna Rotuno. It's on YouTube as well. Flood her comments with a bunch of juice boxes, so she's completely confused. That would make my day. And speaking of attorneys that you would call, she'd probably be on my short list as well. We didn't get into all the wonderful female defense attorneys out there, but she's one of them. And that's the answer to the question. I think I don't know, Dawn, if I would say it's the hardest crime to prove, but I think the saying is more that it's harder to prove than murder, which seems ironic. And that is true. Attempted murders are more difficult than murders. Why? Isn't murder more serious? Sure. But here's the problem, and Donna outlines this. You have to show specific intent to kill with attempted murder. With murder, if somebody intended to somebody could say, well, I didn't intend to kill, I intended to scare, I intended to threaten. Yeah, well, somebody ended up dead. So we're going to substitute that intent for the intent to kill. And we've got ourselves a murder. With attempted murder, it's not enough to prove they intended to cause great bodily harm or serious bodily injury or scare that person or, whatever else, threaten that person. You have to show they intended to kill that person in order to form the requisite intent for attempted murder. So that's why it makes it more difficult. I would say there's there's other crimes that are, I don't know if they're more difficult, but certainly prosecutors avoid them. Paper crimes were always something that most prosecutors avoided like they were the plague. And they just, I don't know. I don't know what to do with this. I don't know what to do with a bunch of paper and a bunch of bank records. And you're telling me something happened. I'd much rather be, where's the photos of the dead body? Let me go ahead and prove that case. Great question, though, Dawn. And big shout out and thank you to Donna. There's all her social media and all her links. So please let her know that we appreciate her joining and helping out today. All right. Oop, let's keep it rolling. That was Dawn from Hoboken.
Hello, Courtroom Confidential. My name is Sherry. I'm calling from Blackfalds, Alberta, Canada. First time caller, long time listener. Josh, I really need you to explain to me exactly what does somebody being charged as an adult mean? I always thought that if someone was charged as an adult, that meant they went to adult jail, prison. Is that not true? Thank you.
Sherry from Black Falls, Alberta, Canada, putting you on the map. Didn't we have at one point like a contest of who was our northernmost? Oh, no, sorry. Oh, no. But not even close. Sorry. Where is that? That's way up there. It's getting like towards the Arctic Circle, isn't it? Good grief. Anyhow, Sherry, thank you so much for calling in. Thank you for being a long time listener and for being a first time caller. Always love that and appreciate it. What does it mean to be charged as an adult? And you're right. You do go to adult prison. That's the biggest part of it. Every state's going to handle this differently, but they're all basically the same. I'll explain it to you as best I know here in California. But you've got the juvenile justice system and you've got the adult justice system, which we just, that's the criminal justice system. Juvenile court is very different, very different. And the biggest difference is the goal. the goal in juvenile court is to get young people back on track. And so it's very focused on the defendant, who's not even referred to as the defendant. They're referred to as the minor. What can we do? How can we help? This person's committed a crime. How do we get them back on track? How do we get them back in school? How do we get their parents more involved? The parents are in court every single day. The parents are put on probation sometimes. The parents are told, I want you doing X, Y, and Z. The other big difference is the punishment, if they remain in juvenile court, is not nearly as severe. The most that a juvenile can get in California, even if convicted of something like a murder, is that they're put in juvenile detention, usually what we call a camp, till they're like in their mid-20s, 26 years old. They have to be released. And that's it. And then their records are sealed. Their juvenile record is confidential. And it's this idea, for the most part, of you've got people whose brains are not fully formed, and you want to try to get them to back to being a fully functioning and successful member of society. Adult court is about, we're going to put you in prison. Yeah, there's considerations to helping people out and putting them on probation and getting someone who's struggling and wayward back on track. But you commit a murder, we're trying to figure out how to put you in prison for a very long time. So that's why much of the battle in juvenile court for young people is about keeping them in juvenile court. Because if they go off to adult court, it's kind of game over. Now they're looking at decades in prison, as opposed to, spending a few years in a juvenile camp. They're talking about spending perhaps the rest of their life in state prison. So that's the big difference. There are many big differences, but the most significant takeaway from this, Sherry, is it's a big difference. Now, what happens when a juvenile, a minor, is charged as an adult? Well, in many states, California included, they have to make certain findings. Is the crime especially heinous? Let's talk about a murder case. Is this crime especially heinous? Yes, it is. Does the juvenile have any kind of juvenile record? Does the juvenile, how old were they? There's a big difference between a 14-year-old and a 17-year-old, right? A bunch of other factors are taken into consideration, but the biggest question for the judge becomes, are they amenable to rehabilitation? If the judge feels, based on all those different factors, that no, they are not, then they are transferred up to adult court, and that's where it becomes a whole different ballgame. So many times someone will be arrested as a juvenile and they'll have a hearing about transferring them to adult court, but sometimes they will do what's called direct filing, where if somebody commits a murder and they're 17 years old, they're just going to file on them as an adult and deal with the objections to that afterwards, about trying to pull them back to juvenile court, much more difficult. And it's becoming less rare in certain jurisdictions to direct file, but other jurisdictions routinely direct file on people who are very young. What was the case? Oh God. The young girl, she was like 14, 15. She shot her mom and tried to shoot her stepdad. She was direct filed on. Carly Gregg, that's it. That was a case where they direct filed on her as an adult. And she was 14, 15 years old. So it does still happen, but great question, Sherry. What state was that out of? Now that's the follow-up question, ladies. Oh boy, here we go. Somebody's going to give me the answer. While you guys are figuring that out, let's move along. Mississippi. There you go. Well, there you go. State, like I said, certain jurisdictions play less games. Put it to you that way. The Crafty RN, thank you so much, says 228 to 600 goal for Father's Day and TIFF. I'll take that. That's good. We could get there. Can we get to 600 for gifted memberships? I think we can. All right. Hit that like button. Like I said, it is tax-free. I would say it's a tax write-off, but it's not. but the government won't know. So go ahead and hit that like button, everybody. All right, where are we off to next?
Hello, Courtroom Confidential. My name is Sherry. I'm calling from Blackfalds, Alberta, Canada. First time caller, long time
Oh, we
listener.
just did this. Sorry. Ritter. Here we go. I'm like, that sounds familiar. Black Falls.
Hi, Josh. This is Tracy from near Seattle, Washington. I have a question for you. There's an emerging story about a woman out of Utah named Elleshia Seymour. She took her 4 children who she only had partial custody of, ended up in Croatia, and the teenage son of a female friend of hers in Croatia Googled the kids' names and found out that they had been kidnapped and alerted authorities that these missing children were in Croatia. The mother has been extradited back to Utah and has been charged only with one charge. I think it's of child endangerment. And if you could, but there's 4 kids involved, like 3, 8, 11, and 13 or something of the sort. Why only one charge of child endangerment, not one for each child? Anyway, thanks. Have a good day.
Tracy from Seattle, Washington. Let's put you on the map. Yeah, the Elleshia Seymour case. This one's a wild one. I mean, quickly to answer your question, these charges are not going to remain that way. And we'll get into why that is, but this is just right now they're working on getting her. I believe she has been extradited, or they were in the process of extraditing her, but I fully imagine the charges will change and there will be more than one charge. If it remains as one charge, the answer to your question is I have no idea. I have no idea why they would only charge her with one count when they've got 4 children involved here. But to understand what's going on here, Elleshia, this is out of Utah, started to have some sort of mental break inspired by some extreme religious beliefs. She became obsessed with the apocalypse and started communicating with people online, and that, of course, spun her out, including people in Europe. And there was apparently a woman in, I think the woman was in Croatia. I read the media coverage on this, and it's not entirely clear, but she contacted someone in Europe, and I think it was Croatia, who invited her, who shared the same apocalyptic beliefs, and invited her to bring her family so that they could all hide out and survive the apocalypse. This woman, now authorities believe, had no idea that this woman was bringing her children without the father's permission or knowledge. She had forged some passport documents. I mean, you can't put kids this age on a plane to another country without getting passports and signatures and everything else. And she'd forged a bunch of documents. I believe the husband's name is Kendall. He was unaware of all of this. There's Kendall. She gets them all on a one-way flight from Utah to Europe, and they disappear. And the story becomes even more nightmarish for the father, because once you are right, someone does a little digging and finds out, hey, wait a minute, these kids have been kidnapped, and alerts the Croatian authorities. The Croatian authorities arrest her, but then stick the kids in an orphanage. And then the father had a great difficulty getting them. He went out to Croatia. He was only granted limited visitation with the kids. The kids are living in a foreign country where they don't speak the language, and they're living in a orphanage. It's a nightmare for these kids. And there was all this red tape and findings and hearings that needed to take place. And I'm not even sure as to the status of all of that. The media coverage of this has not been all that extensive, other than she's been arrested. They're extraditing her back, and I believe they are in the process of getting the kids back as well. But what an absolute nightmare. And I don't know if you can point the finger at, other than her. I don't know if this is a fault in our system, that you can so easily get kids, think about it. If she had just had someone who was in on the plan, these kids might have disappeared. They might have been in another country. And if some good-hearted person hadn't come forward, he'd still not know where his kids are. She was on a one-way ticket, and I don't think the ticket was to Croatia. I think it was to Italy first, and then they made their way to Croatia. Really sad. She obviously needs some help. I don't know what's going on with her, but that's the story on that. So we will, if you guys are interested, keep you updated as to the progress of this one. But we'll leave it there for now. Thank you so much, Tracy from Seattle, for asking the question. All right. Where are we off to next here? Here we go.
Take 556. Hey, Josh. Hey, CC fam. This is Bluebird 711 coming at you quite breathless after how many times I've tried to record this. Anyway, my question is concerning the Supreme Court's decision today in Hunter versus the U.S., where the court held that waivers and plea agreements are not always ironclad. Specifically, courts don't have to enforce them when doing so would result in quote unquote miscarriage of justice. Could you explain to me exactly what that means, or kind of the scope? I guess my biggest concerns are, will this decision give an open door for Bryan Kohberger in the future to appeal now? And also, I wasn't sure if it would have to be further broken down by the state of Idaho to adopt that ruling, or how that really works. I'm unsure, and I'm out of recording this question 500 more times. I hope I make some kind of sense and you can understand what I'm trying to ask. Thank you so much. Bye.
Bluebird from Bluebird. Great question. Sorry you had to record it so many times. I'm going to ask you to do it one more time because you didn't give us your location. So wherever you are in this world, on this planet, hopefully not the moon, we can put you on the map next time. But great question. Have I said that we have the smartest community on YouTube? If I haven't, I'll say it again. We have the smartest community on YouTube because I defy you to chat with all of your non-courtroom confidential friends casually about the recent Supreme Court ruling in Hunter versus U.S. and tell me what kind of sideways looks you get. First of all, anytime we're going to talk about this case, anytime the name of Bryan Kohberger is invoked, I think it's important for us to acknowledge the loss of life of these four angels: Kaylee Gonzalez, Madison Mogen, Zena Kernodle, and Ethan Chapin. But your concern, Bluebird, is the effects that this Supreme Court case might have on the plea taken by Bryan Kohberger. And I don't think your concern is misplaced, but I will tell you, don't be concerned. What happened in Hunter versus U.S. is this is a case from the Supreme Court just made a ruling in June of this year. So this month, really recent. And I would have explained to you the actual facts and circumstances of the Hunter case, but it's very in the weeds, and it's not all that helpful to understanding what the ruling actually is. What the ruling is simply the idea that an appeal waiver is not bulletproof against miscarriages of justice. Okay. You cannot enforce an appeal waiver that would result in a miscarriage of justice. What would that be? That would be a judge taking a plea, taking an appeal waiver, and then sentencing someone to far beyond the statutory guidelines or limits of that person, how that person was sentenced. That would be a miscarriage of justice, right? We can all agree that if a person takes a plea for a, and by the way, appellate waivers are pretty much standard a part of pleas. Okay. Like these are not new things or rare things. Appeals, waivers of appellate rights are baked into most pleas. Let's say you take a plea on a DUI and the judge says, I'm sentencing you to 10 years in prison. That doesn't mean that you now cannot, the Supreme Court saying, hey, that's a miscarriage of justice, and we're going to allow for that person to still invoke their right to appeal, even though they waived it during their plea. It's a pretty extreme example, but you think about it, we already kind of talk about this in appellate waivers when we talk about something like ineffective assistance of counsel. Remember, we've already talked about, even before Hunter, we talked about how a rare example might be ineffective assistance of counsel, where the defendant could later on claim, I didn't understand what I was pleading to. I didn't understand that I was giving up my appellate rights when I pled. That's why you see in the plea of Kohberger, the judge spent an extraordinary amount of time of explaining to him what he was pleading to and getting him to waive his rights and getting him to acknowledge that he was waiving his appellate rights, and on the record from his own mouth, waiving his appellate rights. Because we don't want down the road someone like Kohberger to say, I didn't know what I was doing. Nobody advised me. I had no idea what was happening. Because that is something that can survive an appellate waiver, because it's the same concept. It would be a miscarriage of justice. And so that's really what the Supreme Court was doing here. And they even acknowledged that the situations it would arise in would be incredibly rare, very serious, and under extraordinary errors. No shocker here. They're not changing the landscape. They're just saying, listen, the justice should be the end goal here. And if there is a obvious miscarriage of justice, we're not going to say that that person's locked into that merely because they waived their appellate rights. And I hope that makes sense. So no concern here. The man's not going anywhere. He remains a monster in prison for the rest of his life. Thank you so much, Bluebird, for asking that question, though, and for continuing to demonstrate what an incredible community this is. All right. Let's keep it rolling. Sorry, I just lost my place. Here we go.
Hi, Josh. This is Natasha from Charlotte, North Carolina. And my question is about cases where the police know somebody did it, but they're not sure to pinpoint who specifically. Like, for example, I've been hearing a lot about Summer Wells lately because it's the 5th anniversary of her disappearance. And then also in the Robert Vaughn case, they have a pretty good idea that one of the 3 men that were in the house that night killed him, but they're not sure which one. And with Summer Wells, I think it was one of her parents, but they can't pinpoint which one. I was wondering in those cases, could it be possible where that victim never gets justice because the police aren't sure exactly which one of them was involved? Or is there any way to charge these people, I don't know, as a group or something, even though they're not sure which one of them did it. Thank you. Bye.
Natasha from Charlotte, North Carolina. The Carolinas just got together and said, let's show up for Sunday Funday. Thank you so much, Natasha, for putting Charlotte on the map, and for highlighting the Summer Wells case. This is one that I was not all that familiar with, so it's a good opportunity for us to, oh, look at that beautiful little face. Good opportunity for us to talk about this one. But you kind of answer your own question, Natasha. I mean, you even in your question, you're saying, what do the police do if they're not sure? Well, if they're not sure, how are we going to be sure? How is a jury going to be sure? I mean, does it end up that you just simply don't bring charges? Yes. Sadly, tragically, yes. And it happens. It happens more often than we would ever hope, but it does absolutely happen. Summer Wells, a 5-year-old beautiful girl, from Tennessee. This is Rogersville, Tennessee. She goes missing in June of 2021. And my understanding of it is that she was in the home with her family, and the last they know, or at least what they're saying, is that she went down to the basement, and that's it. The family was still inside of the house, and they've got nothing. This is back in 2021. The reason that it's kind of making the news now is we've come up on the 5-year anniversary of this case. For 5 years now, no arrests have been made. There was recently, investigators shared that there was some development in the investigation that they're looking into, some lead perhaps, but didn't share any details of what that meant. Just one of these things that keeps you up at night, certainly as a parent, that, you know, even with as statistically low as it is, the idea that a child can just simply disappear with no trace is just, it's hard to imagine we live in a world like that, but that's where we're at with her on this case. Now, her parents obviously are one of the suspects. Well, police are kind of doing that same thing where they're saying no one has been cleared. So I don't know if they've ever been declared a suspect. I know that a lot of people are suspicious of them because they have a checkered past, put it that way. This is Dawn and Candace Wells. There's been arrests and allegations of domestic violence. He got a DUI and then violated probation. I think even recently he made a statement. He made that statement from in custody. Their other children had, and might be currently, but had at one point been removed from the home by child services. I think it was unrelated issues. Lot of reasons to raise eyebrows here, but nothing for, or at least not enough for police to make an arrest. So Natasha's question is kind of like, well, why don't we just arrest them, put them on trial, and let a jury figure it out? Well, that's just not the way we do things. We do not just kind of throw stuff up against the wall and see what sticks. You have to have a belief that you have proof beyond a reasonable doubt before you're going to bring charges. Police can make an arrest based upon probable cause, which is a lower standard. But prosecutors should not, I wish I could say could not, but should not file charges unless they believe that they can put that evidence in front of a jury of 12 people and convince them beyond a reasonable doubt that a crime was committed. And if you've got a situation where they don't know who did it or which one of them did it, or if they both did it, or if they didn't do it, then you're not there yet. And yeah, it's sad, but baby Summer might never receive justice. We might never find out what happened to her. And that is something that makes me very sad. What a beautiful little girl. Very sad situation. But thank you, Natasha, for highlighting that all for us so that we can continue to track that one. All right. Where are we off to now?
Hey Josh, this is Maureen from Monterey. I have a question that is similar to one that you recently answered about what defendants are writing when they are scribbling in their notepads and whether that's considered something that becomes part of the trial record. I have wondered the same thing about judges because I often see them writing things down, and I'm wondering if they're just jotting down important points that are brought out in testimony, or if perhaps they are answering other questions about other cases they've got going on, if if they're sort of moonlighting in real time. And then if they are writing notes about the trial and the current testimony, does that then become part of the trial record, or is that considered work property? Anyway, would love your answer on that. And thanks again for everything you and Tiff and Kaylin and the mods do. You are the best.
Oh, Maureen from Monterey, you're the best. Thank you so much for calling in and for being such a faithful, long-time listener. What are judges taking notes on? Well, I am not a judge. I don't think I could ever be a judge. People ask me that every once in a while. You ever want to be a judge? No. I would just the whole time want to jump off the bench and tell them what they're doing wrong. And not even because I feel like I do it better, but I just can't stand to be on the sidelines watching somebody mess it all up. So I don't know what they're writing is the long and short of it. I do have an idea. And I wanted to ask a judge. I've got a few friends who are judges. I'm old enough now to have friends who are on the bench. Nobody's going to come on camera. No judge is ever going to come on camera here to talk about this and give us an answer. So don't think that we've got a phone a friend coming in anytime soon on this. But I, in my experience, know that some judges, like anybody, some are taking extensive notes and others are not. And others, I'm barely keeping them awake when I've been in trials. And it's just up on them. There's no rule about it. The judges who are taking extensive notes are writing down, they know that they're going to have to make rulings on certain things. So they're writing down the case as they, to help them understand what's taking place. Remember, too, judges are hearing this evidence for the first time, just along with the jurors in much of the case. Yeah, there's been a prelim. Maybe they've heard some testimony, but many times there's a lot of new stuff they're not hearing. And it might be that the trial judge is not the prelim judge and could read the prelim transcript, but that doesn't have all the evidence in it either. Certainly when you've got somebody like the defendant testifying, might be the first time anybody's heard what this person has to say. Judges are also doing other stuff. They're keeping track of the exhibits. What number are we on now? What exhibits have been marked and which have not? Which exhibits have certain foundational issues? Will those exhibits be admitted into evidence? Things like that. But yeah, I've been in front of judges who are taking copious notes. And I've been in front of judges who I don't think I've seen them scribble one thing out. And there's no rule on it. Maybe some of them are doing Sudoku. I don't know. Is that it? Sudoku? But I know end of the day, you're never seeing those notes. No, they do not become a part of the official record. Those notes are likely destroyed afterwards or kept in the judge's own personal files. And they are not work product. This is not attorney work product. No one's getting their hands on those notes. Those are the judge's personal thoughts and musings and kept to themselves. And I've never even seen a situation where anybody has even dared ask for those notes. So hope that clears things up a little bit for you, Maureen from Monterey. All right. You guys having fun? Are we having a good time? We've been to the Marshall Islands. Therapist, thank you so much, says, Happy Father's Day to the great dad showing up and doing it right. To anyone in pain, sending love and strength. That's very kind. Best dads bye. Bad dads bye. Huge congrats to moms doing both roles like absolute badasses. Thank you for that, therapist. That's I couldn't agree more. The Crafty RN says 1.2 thousand watching and only 490 likes. We have the power. Yeah, what's going on? You guys not liking this one? Half of you maybe not liking it so much. Hit that like button, everybody. It helps us. I don't know what it does. I feel like it scratches an itch for YouTube, and then it like kind of lets them know to send the video out there. So please hit that like button if you haven't already. And if you're enjoying this ad-free, please hit the like button. That is true. If you're watching this right now, we are not going to allow YouTube to interrupt with any of its nonsense. So we appreciate your support, and we appreciate you hitting that like button. All right. What was I talking about? Oh, yeah. Where have we been? We've been to the Marshall Islands. We've been to Seattle. We've been to Tulsa. We've been all over the Carolinas, coming in hot today. And a lot of interesting cases that I haven't thought all that much about. This Summer Wells one is one that's going to haunt me for a while. Elleshia Seymour is another one. All right. Get it together, Ritter. Here we go.
Well, happy Sunday fun to y'all. Joshua, Tiffany, Kaylin, our terrific mods, CC, family, and guests, Elleshia K. Mayo in Humboldt, Tennessee. First things first, happy Father's Day, Joshua. And I got a journalized question for you. Let's say I need a defense attorney. What would you say are the top 2 questions you should ask any potential attorney? And can you settle a debate that I saw recently online? Does it make a hoot or a holler where you go to law school at? I personally don't think it does. I think it matters how intelligent you are about the law and how possibly creative you are within the bounds of the law. But I could be wrong. Now, to the rest of you out there who are fathers or in a father's role, happy Father's Day. We appreciate you all. And to make Josh's Father's Day extra special, tap that like button once, share the video, and even chat. It's all free. And I hope y'all have a great Sunday Funday. Oh, wait, before the bye. No, I do not need a defense attorney, nor does anybody I personally know need a defense attorney. So have a great Sunday Funday, y'all. Bye.
AKM from Humboldt, Tennessee. Always puts a smile on my face. First of all, it does not matter a hoot nor a holler where your defense attorney went to law school. Not in my view, not at all. Criminal defense work is one of those areas of the practice of law where I think the most important thing is far more experience and personality than anything else. If you are hiring a lawyer to take your company public, probably want to know that they went to a good law school and that they're working at some white shoe, big law firm. If you're asking somebody to defend you for a crime in court, I think you want 2 things out of that person. I think you want experience specifically in the crime that you're committed with, experience in the jurisdiction where you're accused. I should have said the crime you're accused of. And that you get along with that person. And that's what I mean by personality. You're going to be living with this person for a while. You're going to be living with this lawyer for a year or 2, maybe longer sometimes. Do you like that guy or girl? Do you feel like this is somebody that you trust and can get along with? I tell this to clients all the time. Yeah, I'm like, if you hire me, fine. If you hire somebody else, Whoever you hire, though, make sure that you're just like this person and get along with them, because you're going to be dealing with them. You're going to have phone calls. You're going to have really bad phone calls. You're going to have things take place in court that aren't that great. Do you get along with this person? That is a gut check. That's not even a question. Do I think that you should care about where they went to law school? No, I don't. I really don't. I mean, it's so funny when you graduate from law school, like the first thing you want to do is get your diploma out and put it on the wall because you feel like you've made it. I don't think I have ever been asked by a client or anyone where I went to law school. I mean, amongst my friends, we've talked about it because it's like, where'd you go to law school? Oh yeah, you went to Tulane. Oh, how was New Orleans? Blah 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 blah. But it's never been a thing where, oh, that guy went to Harvard. In fact, maybe even works against you. It's like, well, okay, dude, we're out here in the muck. This is the Wild West. I don't know how much Harvard's going to help you out here. It's experience. If I were looking for an attorney, I would want to know, do you know the judge? Do you know the prosecutor? How long have you been practicing in this jurisdiction? How many cases like this have you handled before? How have those turned out? Now, I will tell you too, success rate is not necessarily the biggest factor. And you might say, well, that sounds ridiculous. But yeah, but think about it. No attorney, I don't care how good they are, is going to be a 100% acquittal rate. They're going to lose the vast majority of their cases. That's just kind of how things go. But I would want to know, do you get along well with these people? Have you had success in settling things and negotiating things? These are, I think, far more important. I will say this, one last kind of parting piece of advice on this. Don't hire whoever seems to be promising you the best outcome. If you've got an attorney who's like, we're going to handle this. We're going to get you, we're going to take this to trial. We're going to get this. You're going to get a not guilty. You don't want that jerk. I want the person who's being honest with me. I want the person who's looking me dead in the eyes and goes, this doesn't look good, Ritter. This does not look good, but we're going to try our best. And we're going to leave no stone unturned. And we're going to go and try to either get you the best deal that we can. And if we can't, then we're going to go to trial. Anybody who likes going to trial, also a red flag. What are you talking about? Don't you want a good trial attorney? Of course you do. But they're playing chicken with your life. I tell clients all the time, if we're going to trial, something fell apart. Something went wrong. I want to try to get you out of this sort of going to trial and get you some sort of guarantee where you can move on with your life. If we're going to trial, something went wrong. Anyhow, just my 2 cents for whatever it's worth. But thank you so much, AKM from Humboldt, Tennessee. All right, let's keep it rolling here.
Josh and CC crew, this is Afton in Harper, Kansas. My question is about Luigi Mangione. I just saw that he withdrew his intention to plead extreme emotional disturbance. Will that have any impact on his case going forward? Can prosecutors use the fact that he had put it forth and then withdrew it against him in court? Thank you.
Afton, so good to hear from you. Afton in Harper, Kansas. Let's put you on the map. Which dot am I looking at here? That dot. There we go. There's Afton. Afton, when she is not participating in the sport of equestrian dressage, is asking some fantastic questions on Courtroom Confidential. So thank you so much for being here, Afton, and for this wonderful question. First, I will say to everybody listening, let me direct you to the recent weekly roundup that we had here on Courtroom Confidential, where we went into this whole thing. What's going on with the defense? First, they're saying we're doing a psychiatric defense. A day later, literally Wednesday, they filed paperwork to say they're going to do this defense. Thursday, they withdrew that in a one-page sentence to the judge. So what's going on here? And will the idea that they even proposed this cause some sort of trouble for them? Let's get to that question first, because I feel like a lot of people online have run a little wild with this. No, they're not going to. This is not some sort of admission of guilt because they had proposed to the judge that they're going to go with this defense. Now, had they actually pursued that defense, or they could change their mind again, by the way, if they do actually pursue this defense, it could potentially create some problems for them on the federal case. Because remember, he's got two cases going on here. He's got the state case in New York and then the federal case. The state case is going first, and that's the case where we're talking about right now, where they had proposed a psychiatric defense and then withdrew it. Now, how could that cause problems on the federal side of things? Well, not in the argument. You're allowed to, we talked about this before, make arguments. Arguments are not evidence. But if you have to admit his psychiatric reports, and those psychiatric reports include admissions to the crime to his psychiatrist, and those reports come in because he's waived his hearsay and HIPAA rights to those documents in order to facilitate his psychiatric defense, well, then the federal guys are going to take a keen interest in those admissions, and that likely will be something they want to admit in the federal case. But short of that, just bringing up the idea of the defense is not going to cause him any trouble. So why did he withdraw it? Well, to the point that we just kind of discussed, his attorney there on the left, her name is Karen Friedman Agnifilo. She's married to the guy on the right, whose name is it Mark? Mark Agnifilo? I think so. A husband and wife team. Very good attorneys, by the way. They've done a phenomenal job. I mean, you got to give it up for them. They've done a phenomenal job in their representation of him. They got the case reduced from a first degree to a second degree on the state side. They got the death penalty off the table on the federal side. They're just doing nothing but hitting doubles and singles here. But now they've run into a bit of a problem as to, okay, well, what's our defense? I think the defense of extreme emotional distress is what this is. It's not exactly an NGI defense. It's a defense of mitigation. They're trying to say, hey, you can't really say he intended to kill because he was suffering from this extreme emotional defense. That to me is a defense of desperation. That's when you don't got a good alibi. You don't have a justification. You don't have real evidence that he didn't do it. So you want to say he did it, but he had problems, jury. Karen said, if, quote, if a defendant goes with an extreme emotional disturbance defense, they're essentially admitting publicly that they committed this crime. Yeah, that's the problem, is to pursue that somewhere along the line, they're going to have to acknowledge that he did the thing, whether that's through the experts who have spoken to him or through his own testimony. I mean, how do you put on this defense and have it both ways? Ladies and gentlemen, he didn't do this. But if he did it, he had some real problems when he did it. You can't walk. There's certain lines you can kind of walk both sides of. That's not one of them. Now, is that why they withdrew it? I don't think so. They've known that issue that she identifies. That's not like something that snuck up on them. So what changed is my question to all of you between Wednesday and Thursday of this last week, that they went from, yeah, we're doing it, to no, we're not. Well, I think the answer might be sitting right there at the table. I think he may have changed his mind and said, no, I'm not turning over my records. I'm not turning over. And why would he all of a sudden decide to do that? Could have been that the judge finally said, yeah, time to turn him over. And when he realized what that actually meant, he said, no way, no, thank you. But I don't think this was some sort of strategic blunder. I think this was more him. I mean, whenever you see these situations where it does seem like it doesn't make sense, look to the guy in the handcuffs. That's usually where those decisions are coming from. So I think he's, you know, plus on top of all of it, it's not a winning defense. How are you? The biggest win, like I said, the defense has done a good job, but where this case all kind of got lost, in my view, is when the judge allowed that journal to come in, that manifesto that they've referred to it as. How are you going to argue that a guy who planned and calculated and obsessed about and identified his target in a manifesto for days, weeks ahead of time, that kind of premeditation and cold calculated deliberation then just snapped? That's not a snap. That's premeditated murder. I don't think you can make the argument of extreme emotional distress when you've got that journal coming in. So we'll see. We'll see what their defense actually is. I think their defense is just going to kind of be one of those 1,000 cuts defenses where they just say, hey, you know, you can't see him on the video, and hey, officer, when you jumped to some conclusions here, didn't you? And hey, blah, 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 you know, that kind of stuff. I don't see it being all that strong. Anyhow, we will continue to watch that one. Thank you, Afton, from Harper, Kansas, for asking that question. All right, let's keep it rolling here. Nope. Not my fault. Pressing the buttons.
Hey, y'all. Court Dog Daniel here. Hey, CC crew. So the Fotis Dulos case went really viral here in July of 2019. Also, the Michelle Troconis case that followed. The husband was accused of killing his wife and his girlfriend who was with him as he was disposing of evidence, and the body was never found. In a huge twist, Fotis was released on bail and later died by suicide in his garage, leaving her to face the charges alone. Her case was really about what she knew and when she knew it. She was convicted and then revisited the case through a habeas petition. She was arguing that her attorney was ineffective for allowing her to give multiple police interviews without any deal or immunity. And after a multi-day habeas trial early this year, the judge rejected the petition. He concluded that the attorney's representation fell within the range of reasonable professional assistance and that the strategy of cooperating with law enforcement was not constitutionally ineffective. So Josh, 2 questions. What's your understanding of a habeas petition and how it differs from a regular appellate issue? And have you or would you ever encourage a client to cooperate with police without legal protections? Happy Father's Day, brother. Juiced.
CDD from New Britain, Connecticut. Thank you so much, my friend. Always great to hear from you. And happy Father's Day right back at you. Fotis Dulos and Michelle Troconis. We did follow this one. Another wild one out, I think, wasn't it Massachusetts area? I think that's where this took place. He was accused of murdering his wife, or soon-to-be ex-wife, Jennifer Dulos. Yeah, it was crazy because the theory was that he killed her, but they never found her body. It was a very Brian Walsh kind of situation. And then they went around, Connecticut, everybody's telling me, sorry. They went around that area and they were tracked doing the same thing as Walsh was, with disposing of items at different trash cans very suspiciously. I mean, it's almost to the point where you can't dispose of a body without a bunch of people being suspicious about what you're up to. So he gets charged, he gets out on bail, and he takes his own life. Michelle is the girlfriend, the new lady, but she's along with him for the ride when he's disposing of all these body parts, allegedly. So she gets charged, I don't think for the actual murder, but in the cover-up accomplice side of it, and she gets convicted. So the only one still standing is Michelle, and she's off to prison. She files a writ of habeas corpus, also known as a habeas petition, And that was just denied. And CDD wants to know, what's the difference? What is a writ? Well, a writ of habeas corpus is different than what we would call a direct appeal. And they're different in their subject matter a little bit. And they're different in their timing. An appeal comes first. And you're appealing things that took place in court, in the four corners of the court transcript and record. So one of the big things on appeal is setting the record. The record consists of all the transcripts of the trial proceedings, perhaps the transcripts of even the evidentiary hearings that took place ahead of time, the items of evidence that were marked into evidence, the objections made on the record, things like that. That's why it's so important to put things on the record. While you'll hear attorneys make these objections and you go, why are they making this objection? That's so silly. They're making it for the record. Sometimes they'll even say, for the record, Your Honor, we're objecting to this, because you have to preserve those issues for appeal. Same thing with the evidence. It's very important what evidence gets admitted, because if it's not admitted, if you just talk about something and you never mark and admit it, the Court of Appeal can't consider it. They don't have it in front of them. They have a very limited universe in front of them. And you're usually appealing on the decisions made by that trial court judge. Evidentiary decisions, allowing certain evidence in or not allowing certain evidence in. Instructions are a big thing. How was the jury instructed? Were the proper instructions given? Were those instructions confusing or conflicting? A writ, a habeas petition, is different in that, I mean, the concept is that you are being unlawfully imprisoned. And that is based on usually things like new evidence. So it's not part of the trial record. It's something new, exonerating evidence has come out. I couldn't bring this up on appeal because it's not an appealable issue. So I'm going to bring it up in my writ to show, hey, I am unlawfully imprisoned because this new evidence came out exonerating me. Or it has now come to light, but it's not a part of the record, that my lawyer was ineffective assistance of counsel. My lawyer didn't advise me of something. So no, though it's not part of the official transcripts, I'm now telling you that my lawyer never told me X, Y, and Z, or my lawyer never called this witness, this alibi, or my lawyer was a drunk and wasn't paying attention half of the time. And you know, those are the kind of outside of the universe of the appeal reasons why you might bring this up on a writ. The other thing with the writ is that it usually comes after you've exhausted everything else. So you've exhausted all of your direct appeals. You made an appeal to the appellate court. They denied it. You tried to appeal that up to a higher court. They denied it or decided to never even hear it. And now you're left with no other remedy but to bring a writ. So it's kind of a last resort. It's an appeal of last resort. And to your other question, would I ever advise a client to participate with or cooperate with the police? Sure, I've done it. And I think that's why her writ wasn't successful here. There's a strategic reason why they might have wanted her to cooperate with police. She was probably trying to make the case of, hey, I wasn't in on this. I'm just driving around with my boyfriend, Fotis, and he's dumping stuff, but he's telling me it's, you know, I don't know what it is. Garbage of some sort, not a human body, certainly not his wife's body, and certainly not evidence. I have no idea what we're doing. But yeah, listen, if you're going to tell your client to cooperate with the police, you better, one, believe they've got nothing really to hide, like they're not going to put themselves in jeopardy, and that they're being very, very honest with you. I'm not saying it happens all the time. It's very, very rare, but I've done it. I've had situations where I've walked them in and said, listen, your best shot here is to tell them everything you know Let's make you a witness, not a defendant. Great question. CDD from New Britain, Connecticut. Catherine Kellen, thank you so much for the super sticker. That's very kind of you. Just Jules, thank you for gifting the membership. Appreciate that. CR Confidential, never heard of them. Thank you. Oh, did we get to that? We got to the amount of likes? Good. That's really nice. So everybody can enjoy a free membership. All right. Get your hankies out, everybody. It's that time. We are down to the final three, but we've had a good day, haven't we? Let's get down to these last three, everybody, shall we?
Hi, Josh and everybody. Happy Sunday Fun Day. It's Hayley from Cornwall. I know you'll get a lot of questions about the George Pino trial, but my question really is how do you think, who do you think has proved the case more, the prosecutor or the defense team? I know they've now taken the lesser charge away, and now it's just manslaughter. So it's going to be quite hard for the prosecution, I think, to prove that charge. I think if they'd kept the lesser charge in, it would have at least got that. I don't know what your thoughts are on this one. It's been quite an interesting trial. I can't hear what the judge is saying, which is annoying. And obviously, I don't think I would have watched it if he hadn't have cried right at the beginning, like a baby. But yeah, let me know what you think. Thank you.
Haley from Cornwall, England. Thank you so much for calling in. Let's put you on the map. George Pino. I know a lot of you guys have followed this one closely. It's a really sad case out of Florida. He is on a boat for his 18th daughter's birthday party. He takes her and a bunch of her friends out to like a sandbar, and they're having drinks and beers and a bunch of drinks and beers and having a good old time. And then he is navigating the boat back to the dock, and he hits a channel marker going 50 miles per hour. And it tosses the boat, and a young lady goes into the water and loses her life. And another young lady is disabled for the rest of her life. Really, really sad. Lucy Fernandez. Just tragic, really tragic. It's, such a fun day, I imagine, for all of them that just turned really, really tragic. And you're asking me, what do I think? Admittedly, I'm going to be honest with you and say I have not watched every second of court. I've tried to watch as much as I can. I will tell you, I do not envy the jury in this case. And I think this might be one of those rare cases where it's going to come down to closing arguments. Closing arguments are going to be tomorrow. And I really think it could be who does a better job of helping jurors interpret the evidence. Because here's the problem. They have no evidence of him being intoxicated other than circumstantial evidence. No hard forensic evidence. They didn't give him a breathalyzer. They didn't perform FSTs on him at the scene. They do draw blood from him 5 hours later. It doesn't show signs of alcohol. He only says that he had a couple of beers, but there's 60 something bottles on that boat. And I don't think if this came down to a case of was he under the influence, I think you'd have to say not guilty, right? I just don't. There's circumstantial evidence, but I don't know if there's enough convincing evidence to get beyond a reasonable doubt. But that's not really what the case is about. The defense, I think, has done an excellent job of trying to make it about that. But the case is really about, was he reckless in the operation of that boat, drunk or not? If he's drunk, that fully works into the prosecution argument. But even if he's not drunk, he could still be reckless. And I think if the prosecution explained to jurors that, listen, this is like a man driving down This is like a man speeding in a school zone on the wrong side of the road who blows through a stop sign. And if you think that that is reckless, then that's what we've got here, because they have proven, I think, that he was going beyond the safe limit speed. He was going 50 miles an hour when he shouldn't have been. He was on the wrong side of the channel in waters that he's familiar with. And he hit this channel marker, which is clearly marked and something fairly obvious in the water. And only somebody who was speeding and on the wrong side and not paying attention and being a little reckless would hit this thing. And as sad and tragic as that is still reckless. So, but it's going to be up to the jurors. Like, is that reckless or is that just an accident? Because accidents do happen. And we're not talking about driving a car where we all can kind of more clearly understand that. We're talking about a situation where you could see someone boating in this manner and it maybe not rising to the level of criminal negligence or recklessness. So I do not envy them. It's a real tough one. You've got a real difficult situation. You've got the loss of a beautiful young girl's life on one hand, and you've got a guy that you could send off to prison that may not be guilty on the other side. What do you do with that? So we'll see. We're probably gonna get a verdict on this thing. I don't know if we'll get it Monday, but we'll probably be talking about it sometime this week. All right. Great question. Haley from Cornwall. Let's keep it going here.
Hi, Josh. My name is Rachel. I am a first-time caller from Ozark, Missouri. I recently started following your channel, and I would just first like to say that I really appreciate the respectful way that you discuss these cases and look at them from both sides. I feel like you're able to provide a really unique and valuable perspective as someone who's had experience on both the prosecution and defense side. My question today is regarding the rules of evidence in a bench trial. Does the judge hear everything and decide along the way what he can or cannot consider to reach a verdict? Or does a different judge make those rulings beforehand? It seems like it would be difficult to just put the excluded evidence out of your mind if you've already heard everything. Does this tend to present any particular issues on appeal? Just curious as to how it all works in that situation. Thank you.
Rachel from Ozark, Missouri. First time caller. Thank you so much. And a great question. And I think the first time we've had someone from Ozark, Missouri as well. So thank you so much, Rachel, for joining the conversation and being I hope you're a subscriber and listener of Courtroom Confidential. I love this question too. This is a great question. Again, a very smart question. If you've got a bench trial, how does that judge handle inadmissible evidence, right? We know how they handle it with a jury. They sustain objections. They have evidentiary hearings, and they tell the parties what they're allowed to present and what they aren't, and sometimes big pieces of evidence, sometimes, crucial pieces of evidence. I think we just heard from the Corey Richens jurors that they found out that there was like phone calls or text messages that they had never seen. Were very, I think, highly indicative that Corey was up to no good, that they never heard about. Well, the judge did. Well, how do you handle that when the judge is the jury, when the judge is the one going to be making the decision? The answer is you expect that a judge kind of knows what they're doing enough and that they are able to hear evidence and not consider it and understand that it exists, but not allow it to play a role in their arriving. They have to do the same thing a jury would do. They have to arrive at that very subjective standard of, is this beyond a reasonable doubt? And how do they do that? While performing this high wire act of ignoring evidence that they may know exists. They do it. We put a lot on them to do it. But bear in mind, too, they spend their careers kind of doing this. Think about it. They are the ones who are making the decision to not allow that evidence in on a jury trial. They may know there's incredibly convincing evidence of the defendant's guilt, but for an evidentiary purpose, they're not going to allow that in. They know they're sending that out there. They know that a jury could come back and say, not guilty, when they have a person that they know from other evidence might be very guilty. But the rules are the rules, and they're going to allow that to take place. And we expect that the same people who are able to do that and be impartial and follow the law can put these things out of their mind when arriving at a decision. No, it doesn't, create any extraordinary appellate issues. It's just what we call upon these judges to do. And I think part of a reason, too, why you don't see it all that often. When you've got a jury trial, you have a controlled universe. When you've got a bench trial, not as clearly defined. Thank you, Rachel, for being a first-time caller from Ozark, Missouri. All right. Here it is, everybody. Who is bringing us home today?
Happy Sunday Fun Day, everyone. This is Jonna from Clemens, North Carolina. Josh, would you please explain the death penalty appeal process? I understand that it goes through the state for errors and then a federal review, and finally a petition is filed for the executive clemency. But if no new evidence is presented and is only determined by the original trial proceedings, then why does it take decades for the death penalty to finally be carried out? Is it because there are so many on death row and not enough state and federal court appeal personnel? I'm ready to carry some of these death sentences out myself. And I'm just enough to do it too. Goodbye, everybody.
That was great. Jonna from Clemens, North Carolina. Love it. Well, you answered your own question. It's a great question. Why does it take so long for these death penalty appeals to see their way through the courts? But you answered your own question. It is, the long and short of it is, it's a bottleneck problem. You've got, people put on death row, and there's just not enough lawyers or time to handle all of it. So every person who gets a death penalty verdict is going to be given an appeal. So you've got to assign that to an attorney who knows what they're doing. Most times these are not privately retained people. If you see, even in privately retained trial counsel, it's usually going to some sort of appointed appellate counsel. Well, they can't just hand that to anybody. They've got to, this is a death penalty appeal. That's got to go to a certain person. And there might not be that many people who handle it in that state. So it takes time. I know that there is, in places like California, there's a backlog of years to get an attorney assigned. We're not even at the starting line. We haven't even picked the runner yet. So that can take years. And then it takes them years to put together the appeal. And then it takes even longer for the appeal to be heard. And then that appeal is not the end of it, because then, like you said, they're going to appeal farther up the state line. Maybe they'll appeal on the federal side if they feel that's advantageous. Maybe they'll take a writ. And then they'll finally appeal for clemency. So it takes a long time. I will say, though, in some jurisdictions, it's not decades. In some jurisdictions, it's far quicker than others. Some jurisdictions like to move this stuff along more than other jurisdictions do. But that's you did a great job of answering it, Jonna. That's why it takes so long, is it's just. And listen, I get your frustration, but end of the day, this is the thing we got to get right. Right? I mean, of all of the functions of a government, the idea of actually putting to death someone should probably be the thing we take the most time in figuring out that we're doing it right. All right, guys, thank you so much. What a wonderful, wonderful Sunday Fun Day for Father's Day. Appreciate you all being here. Let me give you some quick announcements. Don't go anywhere. I'm watching. Let me give you some quick announcements and then get you all out of here and on with your Father's Day festivities. First of all, Check out thecourtroomconfidential.com. If you didn't get your question answered today, don't get upset. Don't get angry. Just ask another one. And the best way to do that is to go to thecourtroomconfidential.com and click on send us a message. And we will do our best to answer your messages every Sunday. 2, membership. Many of you received a membership. Thank you so much for everybody for the incredible generosity in gifting those memberships. If you didn't get one, don't get discouraged. Go to thecourtroomconfidential.com and click on become a member. And that's the best way to do it. 3, merch. You know what's happening? Is today the first day of summer? Or is that happening? Is today's the first day of summer? Ha! What incredible timing. Because we have our summer merch launch from Courtroom Confidential. It's a not my fault, carefree summer from Courtroom Confidential. We've got bags. We've got koozies. We've got slides. We've got t-shirts. Love this one. We've got, oh, wait a minute. Go back to that. I didn't realize, are the sunglasses different? One of them's aviators and the other one's like the, what are those, Wayfarers? You see how you can't get anything by me, ladies? I noticed these details. We've got two color options and 2 sunglass options for you. We've got, what else do we got? We've got flip-flops. This bag is fantastic. I'm a big fan of this shirt. We've got beach towels. These slides are also great. Tiffany wears those every single day. Tan lines and timelines and alibis melt in the heat. All brought to you by Courtroom Confidential. Please check out the shop. Bunch of fun stuff out there. And this handy dandy bumper sticker, bumper magnet. All right, what did you miss? Well, we had the weekly roundup on Friday. We talked about Mangione, and we talked about Tyler Robinson, and we talked about Jennifer Clancy, right? God, I'm having a tough time with names today. Lindsay Clancy. I need rest. Can I have rest for Father's Day? Is that on the table? Okay, good. Check it out. Really interesting developments on every single one of those cases that I don't want you guys to miss. Then we have the weekly rap sheet. That's over on Fox Nation. That is the show that I co-host alongside Paul Morrow and the aforementioned Donna Rotuno. So please check that out. Stay tuned on Monday. Live at 5 p.m. Pacific, 8 p.m. Eastern. That is tomorrow. We are bringing to you a special guest. Dave Ehrenberg was confirmed while we were live on this show. So he will be joining us at 5 p.m. Pacific, 8 p.m. Eastern. And we're probably going to be breaking down the latest in the George Pino case. So join us tomorrow night. Then on Wednesday night, we're back here again, 5 p.m. Pacific, 8 p.m. Eastern. Sunday, I know that you're thinking to yourself, why am I talking about something that's already a week out? We're going to have a time change. So we are now moving Sunday Fun Day to a new time. It will be at 10 a.m. Pacific, 1 p.m. Eastern, just to give you all a little more time to brew that coffee and get going in the morning. CrimeCon is coming up in 2027. Why are you talking to me about that? It's not until September of 2027. Well, they still have advance tickets available. They are at a reduced rate. And on top of that, if you use the code courtroom at checkout, you'll get an additional 10% off. We just didn't want you to miss out on a cheap ticket if you're looking to save a couple of bucks. All right. Thank you all so much for being here. Happy Father's Day to everybody. Big shout out and thank you to David. Oh, I know who that is. Mr. Abe. Thank you so much for the super sticker. That's very kind of you. You're very, very, very sweet gentleman. Thank you to Tiff Ritter. Who's that? Josh, you are the best thing that ever happened to me. Aw, make me cry. Happy Father's Day, babe. Love you so much. Love you too. That's very sweet. She knew she had to put it in a paid comment for me to read it. Catherine Kennel, thank you so much for becoming a YouTube member. That's very kind of you. Be like Catherine, everybody. Is that it? Is that everything? Big thank you to Donna Rotuno for answering that question. Please go check out all her socials and her new YouTube podcast and send her some juice boxes. Big shout out and thank you to the best mod squad on YouTube. Afton, Shy Gal, Kathy, Therapist You Know, and Best Nancy. Kaylin, you're fantastic. Happy Father's Day to you. Tell Papa that we wish him a happy Father's Day as well. Tiffany, you're very sweet, and I appreciate that. And you are the best thing that ever happened to me. We will see you all here tomorrow night, everybody. Take care. Bye-bye.